Many articles and lots of research can be found on racially biased sentencing. You can look up statistics on the states categorized with the most racially biased judicial system, so clearly the issue is very well known. Strides have been taken to help the victims, but what is being done to the ones implementing the acts? The New York Times editorial titled, "They Were Freed from Death Row, Republicans Put Them Back," does well with addressing the issue of racial bias in the courtroom, as well as placing the blame, but fails to address what is being done to the prosecutors and court officials. I'll be discussing the editorial's evidence of wrongdoings of the prosecutors, but lack of mentioning how or if they were punished, the statistics of death row versus minorities, and how these unjust acts go against the Constitution. To begin with the editorial's evidence, the editorial states, Supreme Court once stepped in to overturn a conviction due to a Mississippi man being tried 6 times by the same prosecutor until he eventually received the death penalty. In doing so, the prosecutor used all but one of the peremptory challenges to strike black jurors. Also, it's a document distributed to North Carolina prosecutors in training listed 10 categories of apparently race-neutral explanations striking a jury in case a judge should ask. This was labeled, quote, standard operation procedures. The editorial states numerous examples of how prosecutors display discrimination, but not that any effort was made to fight the discrimination until the Racial Justice Act. For prosecutors to get quote-unquote sloppy, as stated in the editorial, leads readers to assume the prosecutors felt they would not get into trouble and withheld too much power, hence ignoring the Supreme Court's order not to repeal the Racial Justice Act. Then there are the statistics. Based on an article posted on AP News by Martha Wagner, of the 142 inmates on death row, 64% were black. In the New York Times editorial, it states Michigan State University conducted research and found that in 173 North Carolina death penalty trials over 20 years, black jurors were struck at twice the rate of whites, in a state that is more than 1/3 white. This means the majority of death row cases were convicted by all white jurors or averaged 1 or 2 black jurors. And finally, how this is unconstitutional. In repealing the Racial Justice Act and placing the inmates back on death row, some consider this to be considered double jeopardy. Republicans of North Carolina argued, quote, the repeal of the law means the plaintiffs go back to death row. The new evidence that inmates presented towards their appeals and evidence was not taken into consideration when putting them back on death row instead of giving them a life sentence. In a Los Angeles Times editorial, it states, typically in criminal trials, both the prosecutor and the defense lawyer are permitted to strike an equal number of potential jurors based on the suspicion that these people will not view their cases favorably. The notion is that these peremptory strikes will lead to a panel of jurors who can fairly decide the defendant's guilt or innocence. This is due to the 6th Amendment in the Constitution. All people have a right to an impartial jury, so to strike black people from the jury would make that impartial. In conclusion, I have discussed how the New York Times has failed to recognize the consequences faced by prosecutors being racially biased in the courts through the lack of coverage on the matter within the article, statistics pertaining to inmates in death row, and how these acts of prosecutors come off as unconstitutional. If the prosecutors and court officials are not dealt with accordingly, then the issue will never be put to a halt. For every inmate that is helped, another inmate will fall victim to these unjust acts.